Good morning, friends. Let us solve another question. The question number is 2, which was in the examination of first paper of 2019. It says that what is the nature of the petition filed under Article 136 of the Constitution of India? That is, does it filed in the original jurisdiction or appellate jurisdiction or any other jurisdiction of the Supreme Court of India? Under what circumstances the remedy of filing a special petition under Article 136 of the Constitution of India before the Supreme Court can be invoked by a person? Whether an order granting special leave to petition can be invoked subsequently. Now let us answer this question. Firstly, nature of the petition filed under Article 136. French Article 136 provides a special and extraordinary appellate jurisdiction to the Supreme Court of India. It does not confer original jurisdiction. It allows the Supreme Court to grant special leave to appeal against any judgment, decree, determination, sentence, or order in any cause or matter passed by any court or tribunal in India except military courts or tribunal. So the nature of jurisdiction under Article 136 is appellate, what discretionary and extraordinary, not as a matter of right. Now let us dive into second part, that is circumstances under which an SLP special petition can be filed. A person can file an SLP under Article 136 in the following situations: where there is grave miscarriage of justice, where there is substantial question of law of general public importance, where constitutional issues are involved, and the certificate has been refused by the lower court. And in rarest of rare cases, where the Supreme Court feels that legal process needs to be corrected, even if all other remedies have been exhausted. So it is important to note that SLP is not a right. It is privilege and discretion that the Supreme Court may or may not grant. Now, third part is whether an order granting SLP can be subsequently revoked. Yes, my dear friends, the Honorable Supreme Court can revoke the grant of special leave under certain circumstances. If the SLP was granted based on fraud, misrepresentation, or suppression of material facts, then it can be revoked. If during the final hearing, the court finds that the court does not merit interference, it can dismiss the appeal even though special leave was granted earlier. The grant of SLP does not mean that the final decision is given. It only means it is ready to hear the appeal. The court is willing to hear the appeal. So while granting of SLP, it is a step forward. It does not prevent the court from reversing or modifying its decision later on if there is a valid reason. Now, let us summarize the answer. We can say that Article 136 is appellate jurisdiction not original, and it can be filed only in exceptional cases involving miscarriage of justice or significant legal issues. And it can be revoked under certain grounds such as fraud or change in the court assessment during final hearing. So this is all about, friends, answer to the question. Hope you are enjoying videos.